This is the ruling of the court.
Okay, my lord.
The claimants took out a complaint on 14th February 2024. By a motion of 4th April 2024, the defendants filed a memorandum of appearance and statement of defense and counterclaim, and also filed a motion for interlocutory injunction. The claimants claim as follows. The claims are herein set out. The defendants counterclaim as follows. The counterclaim are herein set out. In a considered ruling on 6th May 2024, the court dismissed the motion and raised a question on his jurisdiction so motu and gave the parties 7 days to file their respective addresses. The question is whether by reason of Section 254C of the Constitution of the Federal Republic of Nigeria 1999 as amended, this court has jurisdiction over this matter, given the subject matter of dispute, leadership of an association. The defendants filed an affidavit of 14 paragraphs on 19th May 2024, deposed to by the first defendant, and a written address. It is the deposition of the first of the defendants at paragraphs 5 and 7 that the Association of Master Bakers and Caterers Association of Nigeria is registered under the Nigerian law with the Corporate Affairs Commission on 9 September 2008, Exhibit BOA1, and that the fourth defendant is the zonal body coordinating the affairs of the association of the state branches of Oyo, Osun, Ogun, Ekiti, Ondo, Lagos, and Kwara, that the dispute between the parties is an intra-union dispute, and so the court has no jurisdiction. In his written address for the claimants, Lanet Oladipo Esquire submitted that the dispute between the parties is an intra-union dispute, and so the court has no jurisdiction. Counsel cited some decided cases on intra-union disputes and reproduced Section 254C1JI to VI, underlining VI. It appears to the court that even though the defendant's counsel reproduced the question for determination, he missed the sense or the operative phrase, which is even the subject matter of dispute, leadership of an association, and counsel rather addressed the nature of the dispute before the court. The defendants had deposed that the Association of Master Bakers and Caterers Association of Nigeria is registered under the Nigerian law with the Corporate Affairs Commission on 9 September 2008 as BOA1, and counsel reproduced Section 254C1JI to VI, underlining VI, but yet did not see any relationship between those depositions and the provision with the question for determination. When the court raised this issue so motu on 5th May 2024, the matter was adjourned to 20th May 2024 for ruling. But on that date, Learned Claimants Counsel, who was in court on 6th May 2024, did not come to court and did not send any explanation. There was no any written address in the court's file, and so the court adjourned to today, 27th May 2024 for ruling. Still on the defendant counsel, still only the defendant counsel had filed an address. The claimant counsel refused to file an address. This is less than what is expected of a minister in the temple of justice. Jurisdiction is a fundamental and threshold issue, being the lifeblood and bedrock of all trials. Without jurisdiction, the trial will amount to an exercise in futility and a nullity. I cited the authorities of Okolonwamu and Okolonwamu, citation supplied, GTB versus Stoid Nigeria Limited, citation supplied, Odom versus PTP, citation supplied. A court is only competent to entertain a case when the subject matter of the case is within its jurisdiction. There is no feature in the case which prevents the court from exercising jurisdiction, and the case comes before the court initiated by the due process of law upon the fulfillment of any condition precedent to the exercise of jurisdiction. See Madu Kolo and Madu and Kemdilim, citation fully supplied. Duru and Yunus are citation fully supplied. Of Democratic Party versus Obi, citation fully supplied. I have carefully read section 254C of the Constitution. The only mention of associations is as in section 254C 1JVI, and it provides as follows. Notwithstanding the provisions of sections 251, 257, 272, and anything contained in this Constitution, and in addition to any other such jurisdiction as may be conferred upon it by an act of the National Assembly, the National Industrial Court shall have an exercise jurisdiction to the exclusion of any other court in civil cases and matters. J, relating to the determination as to the interpretation and application of any VI, trade union constitution, or the constitution of an association of employers or any association relating to employment, labor, industrial relations, or workplace. From the above, it is clear that the National Industrial Court shall have exclusive jurisdiction to hear any civil matter relating to the fourth claimant and fourth defendant, being associations registered under Companies and Allied Matters Act, only in relation to the interpretation and application of their constitution, and that is not the case before the court. Case before the court is a leadership puzzle arising from the activities of an association registered under KAMA. A dragnet provision of the jurisdiction of this court is section 254C1A, which is as follows. Notwithstanding the provision of section 254, 251, 257, 272, and anything contained in this Constitution, and in addition to any other such jurisdiction as may be conferred on it by an act of the National Assembly, the National Industrial Court shall have and exercise jurisdiction to the exclusion of any other court in civil causes and matters, A, relating to or connected with any labor, employment, industrial relations, and matters arising from workplace, the condition of service, including health, safety, welfare of labor, employee, worker, and matters incidental thereto or connected therewith. Considering all the questions asked for determination and the relief sought in this case, none is relating to or connected with any labor, employment, etc., or incidental thereto. Neither is any relating to the determination as to the interpretation and application of any trade union constitution, etc., and particularly, it is a dispute in an association registered under KAMA and not a trade union, and that puts the case outside the jurisdictional competence of this court. Where a court finds that it lacks jurisdiction to entertain a matter, the right order to make is one striking out the suit. See Achinehu versus Maxwell, citation supplied, where the court held. Where a court discovers that it has no jurisdiction to entertain a matter, the proper order to make is to strike it out. Also, the case of Adetayo and others versus Ademola, citation fully supplied, was referred. This suit is accordingly hereby struck out. This is the ruling of the court, and it is entered accordingly. Yes, Balogun. Balogun.
We are much grateful for the well-considered ruling, sir. Yes, my lord. We are very much grateful for the well-considered ruling, sir. We pray that Almighty God should continue to elevate your lordship to a greater height. And based on the order made by this honorable court, you shall be applying for a cost.
Cost in cost.
As God pleases, my lord. Most grateful.
No cost awarded.
My lord, I take the hint of the court, my lord. We are most grateful, my lord.
The ruling will be ready for collection by tomorrow.
As God pleases, my Lord. We are very much grateful, my Lord.
Thank you.
Thank you, my Lord.
I think that's all the Zoom meeting. We shall all leave.
Okay, sir.